Previously on the American Justice Podcast.
One of the justices picked up on that because he was questioning, I believe it was Mr. Guerrero that was arguing for the Attorney General's office. And he was asking Mr. Guerrero, even though the state doesn't have to provide motive, isn't it true that your motive is that Brandon was financially irresponsible, confused about his sexual orientation, that sort of thing. And Mr. Guerrero agreed, and one of the justices commented that if that's a motive for murder, then we better put a fence with razor wire on it around every university in Texas, because that sounds like about half of the college students in Texas.
There is an epidemic in America's criminal justice system: the prosecution and conviction of innocent people for crimes they did not commit. Welcome to American Justice. The American Justice Podcast Army works to free men and women wronged by the criminal justice system. It's not only about the innocent who have been imprisoned, but also the victims of the crimes as well. No one deserves justice more than them. And now, here's your host, Scott Pogensy.
Hello, AJ Army. Welcome back to your podcast. This week, we're going to talk about the appeals that Brandon has been through and where his case currently stands. This episode will probably not be as long as most, just because of the action, or should I say inaction, of the highest courts. All right, let's get going. With almost every criminal case, there are two types of routes that their appeals can take. If the state or federal government, when prosecuting your case, violated any federal laws or constitutional amendments, then that takes one route, through the federal appeals system. Examples of this kind of appeal would be ineffective assistance of counsel or illegal search and seizure, and of course, as is in Brandon's case, the state intruding on attorney-client privileged phone calls. This would be a Sixth Amendment violation, violating his right to private counsel with his attorney, whereas an illegal search and seizure issue would be a violation of the Fourth Amendment. We'll discuss this issue first, and then we'll go on to the state appeal. Brandon has both, but this one's a little easier to explain. So, of course, when Brandon's trial attorneys found out that the state, aka Assistant District Attorney Kelly Aiken, had requested Brandon's calls be recorded and turned over to her, they immediately filed for a dismissal of all charges. Of course, they felt like this kind of intrusion into Brandon's defense was egregious enough that it warranted dismissal of the indictment. Most people that I talk to that are not lawyers pretty much automatically assume that this was the case. As soon as I tell them what the state did, their immediate reaction to me is, well, they dismissed all the charges, right? Wrong. I won't go into it all again, as we do have a full episode dedicated to this particular issue, but let's just suffice it to say that it's not as cut and dry as that. Since the trial judge ultimately did not dismiss the charges, the issue on appeal is, did the trial court err by not throwing out the indictment? There are several cases that cover this type of intrusion, at least kind of. There's never actually been a case where someone acting on behalf of the state just straight up demanded a defendant's privileged calls to be recorded and turned over. Most attorneys that have any kind of ethical bone in their body know that this is wrong. Of course, most are not in Hunt County, Texas. However, there are a few cases where a police officer would overhear a conversation between an attorney and their client, or as in one case, a police officer actually reached out to talk to a defendant after it had been established that the defendant was represented by counsel. All of these issues are Sixth Amendment violations. Because of the fact that there was no case exactly like Brandon's, Each side had to try and use case law in these other cases to try and prove their point. I'm not going to go into the legalese of the arguments because of two things. First, I'm not an attorney, so I'm not going to try to lead you astray from the truth and the facts. And secondly, I don't want to bore you to death. If you ever had trouble sleeping, throw the bottle of serotonin in the trash and pick up one of these appeals. That'll put you to sleep right away. I think you have the basics, though. The state says that the removal of the Hunt County District Attorney's Office was enough to cure the taint. No harm, no foul. Brandon's job was now not only to show that the court erred by not throwing out the entire indictment, but now he has to show that his case was actually harmed. As we discussed in the episode about the Sixth Amendment violation, this was made even more difficult because the state and the judge would not allow the defense to cross-examine ADA Kelly Aiken or look at the 40-plus pages of notes that she took from the recordings. You need these papers to make your case? Well, too bad, you can't have them. I'm not sure how they expected Brandon to know that he was harmed when they wouldn't let him look at the documents that harmed him. But again, we're in Hunt County, Texas. Not surprising. Okay, so the first attorney to jump into the mix is a man by the name of Franklin Mick Mickelson. I was part of the group representing Brandon when we first met with him to decide whether or not to hire him. He and his partner were very personable and forthcoming with answers to any questions that Brandon's grandmother had. Ultimately, she decided to hire him, and he prepared a writ to submit to the federal courts. Also, one quick note here. You'll probably hear me use the word writ, W-R-I-T, and the word appeal interchangeably in this episode. The reason for this is, again, that most of us are not attorneys. There is a legal difference between the two, but most lay people don't know the difference. So let's just agree, for the purposes of this podcast, that appeal and writ both mean that we're asking a higher court to review and or change the decision of a lower court. Deal? Okay, good. Let's keep going. So Mick was quite an interesting character. I've always had the impression that he believed in Brandon. However, when I met with him to talk about Brandon's case for the documentary, we spent the first 45 minutes off camera, and oh, do I regret that, with me answering quick-fire questions from Mick as to why I felt Brandon was innocent. And then he would say things like, well, I believe Brandon is innocent too, but that doesn't mean you can prove it, and the like. Let's just say that it was not a wonderful encounter. And then, when we finally turned on the cameras for the interview, his office had a very loud air conditioning system in the background. I asked him if we could turn it off because it would ruin the audio for the interview, and he just flat out refused. Because of that, of course, none of that interview can or will ever show up in the upcoming docuseries about the case. Well, maybe in the blooper reels or under the, hey, this guy is an asshole section. We'll see. So Mick filed the initial appeal on May 27th of 2015. Now, you may be asking, Scott, there's been 6 years between conviction and appeal. What's the deal? Well, as discussed earlier, there are 2 avenues for appeals, and in the meantime, the state avenue is working its way through the courts. But we'll cover that in just a little bit. So Mick filed the appeal, and, of course, the state had a chance to respond. Then, Mick was able to file one final brief in response to the state's reply. It's kind of the exact opposite here as in the trial. Remember how the prosecution got to talk to the jury first and last? Well, because the burden of proof is now in Brandon's lap, he has the chance to go first and last when it comes to filing briefs for his appeals. Okay, so Mick filed his reply to the state's brief on September 10th, 2015. One thing that should be pointed out here, Federal courts and judges do not have deadlines when it comes to these appeals. They can take sometimes as little as 3 to 6 months, and sometimes 5 or 10 years. It sucks and it needs to be changed, but that's the way it is. So if you ever try to ask an appellate attorney about when to expect a decision, expect a smart-ass reply. All right, so when the appeal was filed, it was filed in the first round of the first level of the federal courts. For Brandon, this is what they call the United States District Court for the Northern District of Texas, Dallas Division. That's a long title if you ask me. It was in front of Judge Barbara Lynn. I personally found this quite ironic, as my mom's name was Barbara Lynn Pogensy, and now we're in front of Judge Barbara Lynn? Quite ironic. And I thought it might be a good sign. However, ultimately, it was not. Judge Lynn denied the appeal on January 30th, 2018. So remember that whole no time frame for a decision in federal courts? Yeah, this judge took 2.5 years to decide this appeal. 2.5 more years that an innocent person was having to sit in prison with no answers. As I said before, I'm not going to go into the whole contents of the writ since I kind of outlined it, but there was one thing that I did like that Mick did. Normally, in this kind of appeal, talking only about a procedural issue, you're not allowed to bring up new evidence. However, somehow, Mick was able to talk about the fact that Brandon had taken 2 polygraph tests. That's right. We hadn't really talked about that much in this podcast because Brandon didn't take the tests until after his conviction. But one thing Mick wanted to do in order to make sure that he was representing an innocent person was to have Brandon take a polygraph test. And then, as I mentioned, with Mick being a weird guy, he then had Brandon take another one, just to be sure. The good thing about this is that he was able to point out that the chances of someone that was guilty passing 2 different polygraph tests by 2 different polygraphers is under 2%. To me, this was very powerful, but apparently not to Judge Lynn. As I mentioned, she ruled against him. It would seem to me that if someone is bringing you a writ and telling you that he's passed 2 polygraph tests by 2 different people, you might want to sit up and pay a little closer attention to this one than all the others. Yeah, not so much. Okay, so the next step in Brandon's Sixth Amendment federal appeals is what is known as the United States Court of Appeals for the Fifth Circuit. This court is located in New Orleans. Now that Mick was removed as Brandon's attorney, we had to find a new one. And the man for the job this time was a guy by the name of John Nation. Mr. Nation came highly recommended for federal appeals and had a lot of experience arguing in front of the United States Supreme Court, should it come to that. John filed his writ to the Fifth Circuit on April 20th, 2018. The state had a chance to respond, but in this case, decided not to. I asked Mr. Nation why this was, and he said that basically they don't have to respond and they can just let their previous filing stand. That's what the state chose to do. There is one thing that you should probably understand about the Fifth Circuit of Appeals at this time. You might have heard President Trump refer to the fact that President Obama left a lot of federal court judgeships empty when he left office. This was true. He felt like the incoming president, no matter who that might be, should have a say in the direction of the federal courts. So when Trump took office, one of the first things on his agenda was to appoint and fill all of these federal courts that were missing judges. Well, one of the courts with the largest number of vacancies was the Fifth Circuit. So by the time Brandon's case had made it to them in 2018, there was a new influx of Trump's appointments. This obviously did not bode well for Brandon, as the court refused his appeal on September 20th, 2018. Hey, at least they didn't take 2.5 years like half-assed Judge Lynn did. Anyway, so only one step left. On to the Supreme Court we go. We retained Mr. Nation to write the appeal to the Supreme Court because of his qualifications that we talked about earlier. Plus, John really believed in Brandon, like 100%. Like there was no question in his mind. It's always nice to know that your attorney believes in you when going forward. So the appeals that go to the Supreme Court are known as a petition for writ of certiorari. It's basically a fancy legal term that comes from the name of an English prerogative writ issued by a superior court to direct the record of the lower court to be sent to the superior court for review. Anyway, this was filed to the Supreme Court on December 19, 2018. On October 7, 2019, the Supreme Court refused the writ of certiorari. They refused to hear the case. The job of the United States Supreme Court is to hear cases where the federal lower courts disagree. And there couldn't be a bigger disagreement than what to do with a case where an agent of the state egregiously and intentionally violates a defendant's Sixth Amendment rights by listening to his attorney-client phone calls. Basically, the difference is that there were some courts around the United States that were saying that you need to prove that you were harmed in order to get relief. And then there were other circuit courts that were saying, no, you don't really have to prove you were harmed, it's an automatic dismissal. And then there were even some other courts that were saying, well, not only do you have to prove that you were harmed, but then you have to prove that the harm was egregious and intentional and systematic. However, the court refusing to hear the case basically meant that Brandon's federal appeal on the issue of the phone call was dead. There was no higher court to appeal to, so that brings us to the state issue. Whenever someone is convicted of a crime, they have an automatic right to what's called a direct appeal. This is basically where you ask a higher court, in Texas, they're known as the Court of Appeals, to look over the trial and conviction to see if there was anything that was so unfair that it would have changed the minds of the jurors had it not been present. Their job is also to look over the trial transcript to see if there were any procedural errors. If you've ever heard an attorney, defense or prosecution, use the phrase, quote, preserving this objection for appeal, this is basically what they're saying. They're telling the judge that if you don't rule in my favor, I believe that this will be an issue brought up on appeal should the verdict not go my way. So Brandon's direct appeal was filed by Gary Udishin and Bruce Anton. I wasn't involved in the case at this point, so I'm not sure why the family picked these two attorneys, but I can tell you that Gary Udishin is the president of the Dallas chapter of the Texas Innocence Project. Maybe that had something to do with it, or maybe it didn't. I'm not really sure. On April 22, 2009, the notice of appeal was filed. There were many delays and extensions, but ultimately they filed Brandon's direct appeal on June 23, 2010. I found it interesting that the court record says, quote, brief filed, comma, oral argument not requested. So Brandon's attorneys were not requesting oral arguments. They just wanted the brief to stand on its own. I'm not sure why any attorney would do this. If you're truly fighting for your client, wouldn't you want the chance to give an impassioned plea, hoping that it might fall on some sympathetic ears? I don't know. Maybe they just felt like they had such a strong argument that it really didn't require any further discussion. Or maybe they were just lazy. Either way, the three justices for the Sixth Court of Appeals, Josh Morris, Jack Carter, and Bailey Mosley, wanted to hear from the attorneys. So oral arguments were set for August 30th, 2010. The family, the friends, the prosecutors, the attorneys, they all traveled to Bonham, Texas to hear the oral arguments. For those of you not from Texas, Imagine the most rural place you've ever seen on TV or visited in real life. That's Bonham. Anyway, they heard the oral arguments and retired back to Texarkana, where the court is based out of, to make a decision. It only took a couple of months, but on December 3rd, 2010, they denied Brandon's appeal. Even though they denied it, they definitely had some issues with the evidence. The problem, though, is that there was a decision handed down by the Texas Court of Criminal Appeals the same day Brandon's arguments were heard. Here, I'll let Catherine Ferguson tell you about that.
I mean, I think they picked up on it too, but unfortunately, the day that oral argument was heard on Mr. Woodruff's case, the Texas Court of Criminal Appeals came down with a new decision, the Brooks opinion. And what we had argued is for many years there was a distinction between the standard or burden to prove that a case was legally insufficient and then factually insufficient. And that had been our argument, and that had been my argument throughout the trial, that yes, they've legally proven that somebody murdered the Woodruffs, but the facts are not sufficient to establish that it was Brandon Woodruff. And that's what that was a large chunk of the appellate brief, if I remember correctly, that Mr. Udishin's office did, was that this was a factually insufficient case. And it seemed that the Sixth Court of Appeals agreed with that assessment, but then I come back from oral argument and look at my email and see a significant decisions update email and open it up, and lo and behold, there's the Brooks opinion from the Court of Criminal Appeals that basically gutted that factual insufficiency argument. And I thought, well, we've lost now. That was our big hope, and the Court of Criminal Appeals basically said, well, there's no difference between factual and legal insufficiency. And when they did that, I was like, well, we've lost.
So let me talk for just a minute about legal insufficiency and factual insufficiency. When you're talking about legal insufficiency, that means that you're talking about whether or not a judge's decision on a particular issue was legal or not. Let me give you an example. Let's say that a police officer pulled you over for no reason, and he openly admits that he had no probable cause to pull you over, but it was Sunday, and he just likes to pull people over on Sundays. Then he looks in your trunk, again for no reason, but when he looks in there, he finds 10.7 kilos of cocaine. I mean, let's just say 10 kilos. I mean, this is a pure example, right? Okay. Anyway, he arrests you, and the DA's office charges you with a felony. So you go to court, and your attorney stands up and says, Your Honor, what is all this jabberwocky going on? That officer can't just pull people over for no reason. He can't look in my client's trunk without probable cause. That's a violation of the Fourth Amendment of the U.S. Constitution. We want this case dismissed. And then let's say it's Judge Beacom, who always sides with the prosecution, and he decides to let it into evidence anyway. Then the jury, of course, convicts you. Well, legal insufficiency would be arguing that the judge's decision was incorrect because it went against the Constitution. Even though the facts are there, because by golly, you sure did have 10 kilos of cocaine in your trunk. Well, Brandon's direct appeal had elements of both. Of course, they argued that the Sixth Amendment violation was not handled properly, i.e., the judge only recusing the DA's office and disallowing whatever evidence was gained from listening to his phone calls, even though they couldn't cross-examine Kelly Aiken, the one that violated his rights. Okay, all right, I know, we've been over that already. But anyway, the biggest part of the argument in the direct appeal was that there were just no facts to support Brandon being guilty. The attorneys were basically just summing up what we've talked about this whole season. there was absolutely nothing that tied Brandon to those murders. At least, no facts. There was, of course, supposition and character assassination, but no actual facts. That's what the attorneys were mostly arguing. And as you just heard Catherine Ferguson say, with the Brooks opinion, all of those arguments went right out the window. And sure enough, on December 3rd, 2010, the three justices issued an opinion ripping the state's case to shreds, but basically said their job was not to determine facts, only whether or not the trial was legally sufficient. And they agreed it was. I'm going to read just part of the Sixth Court of Appeals decision. Quote, Number 1, investigation deficiencies. The defense emphasizes a number of deficiencies in investigating the crime. The state failed to fingerprint many items in the Royce City house, failed to perform DNA testing of the bloodstains on the carpet, and failed to perform DNA testing of the hairs found in Norma's hand. Many items were seized, but not logged and stored in an office. These hairs Norma had in her right hand. Although the police speculated the hairs may have been from her assailant, the hairs were not tested. Deficiencies, though, are not sufficient to prevent a rational juror from concluding, beyond a reasonable doubt, that Brandon committed the murders. All right, let's take a little break from that so I can explain what they just said. Basically, what they're saying here is that even though the investigators didn't do a good job, and even though they didn't do all the things that they should have done, that doesn't mean that Brandon's not guilty. So they're leaving it up to the jurors that heard this incomplete case and incomplete investigation to make a complete decision. It makes no sense. All right, back to the decision. Quote, Number 2, the defense suspect, Mike Etherington. The defense introduced evidence suggesting Mike Etherington may have committed the murders. Etherington attempted to bolster the state's evidence. Etherington lied to the police about whether he had personally seen inculpatory statements on Brandon's MySpace page. Michelle reported the missing gun and took the holster to the sheriff's department at the urging of the father of a friend of Etherington. Etherington committed a number of suspicious acts. A number of witnesses testified Etherington and Brandon were in conflict. Gentry testified Brandon and Etherington were not getting along. Williams testified Norma suspected Etherington of poisoning Brandon's dog. After the bodies were found, Etherington made a number of calls to the Royce City house and used star 67 to prevent his name from appearing on the caller ID. The bodies were discovered on the evening of October 18th. The first attempt to call the Royce City house was on October 19th at 12:20 a.m. Michelle testified that Etherington had been to the Lee's house a few days prior to the murders as well. Therefore, Etherington could have stolen the gun. Etherington's phone records indicate he was approximately 5 miles from the Royce City house on the night of the murders. The record, though, does not establish where Etherington lives or where he was on the night of the murders. And then there's the part that talks about the Brooks decision. Section F. The evidence is legally sufficient. Portions of the state's arguments are either marginally relevant or highly probative of Brandon's guilt. The state's evidence merely suggests the missing gun may have been the murder weapon and Brandon may have stolen it. While the evidence clearly establishes the dagger belonged to Brandon and had Dennis's blood on it, the record contains conflicting evidence concerning whether the dagger was the murder weapon. We also note a number of state's witnesses have credibility issues. The plurality opinion in Brooks suggests the confusing factual sufficiency standard may have skewed a rigorous application of the Jackson v. Virginia standard by the Court of Appeals. So there you have it, the whole reason they dismissed Brandon's appeal. They're basically saying here that we have issues. We have a lot of issues with the evidence in this case. But because of the Brooks decision, that's not our job. Gonna have to take it to a higher court if you want someone to actually review the facts of the case. So, that's what they did. They appealed the Sixth Court of Appeals decision to the Texas Court of Criminal Appeals. The high courts in Texas are divided into two parts: the Texas Supreme Court, which deals with tort law or civil law, and the Texas Court of Criminal Appeals, which does just that, criminal appeals. So that's where Brandon's case landed. The appeal is what's called a petition for discretionary review, or a PDR. This brief was filed with the Texas Court of Criminal Appeals on February 7, 2011. Now, you might be interested to hear what these justices had to say about Brandon's case. Well, so would I. They actually refused to even hear Brandon's appeal. What a bunch of dirtbags, huh? On May 25, 2011, the Texas Court of Criminal Appeals refused to even hear Brandon's case. This is the whole reason that we started the petition on change.org. If you go to that site and search for Brandon's name, you should find it. Please go sign it, because very soon we'll be delivering that petition to the Texas Court of Criminal Appeals. Very, very soon we are going to be traveling to Austin as a group and hand deliver these petitions to the clerk. We'll also protest with signs and face masks that say Free Brandon and t-shirts and all kinds of things. We hope you can join us. All right. So that's pretty much it with Brandon's what are called afforded appeals. As far as the courts are concerned, Brandon was charged legally, convicted legally, and deserves to sit in prison for the rest of his life. They never once said that the facts were sufficient to convict him, because the only court that even had a chance to hear that ultimately referred the appeal to a higher court, who of course refused to hear it. So here we sit. What to do? What to do? Okay, so Brandon's literal last chance is what's called a writ of habeas corpus, or more commonly referred to as a writ of actual innocence. Basically, Brandon has to go to court and prove his innocence. The state no longer bears the burden of proof. The burden is now on Brandon to prove that he is innocent. As we've discussed over the whole season, you might wonder how Brandon is going to prove his innocence with an investigation that never really proved his guilt. Well, that's a really good question. And unfortunately, we don't have the answer to that question. All I can tell you is that the investigation is ongoing, and it will hopefully be filed soon. Once there's a development in the case, we will definitely come with a special episode to update everybody. All right, so there we are. That is the current status of Brandon's case now. Next week, we'll wrap up Season 1, and C. Derek Miller and I will both unleash our unfiltered, unchained, and unadulterated opinions. You will not want to miss it. Until then, remember to stay aware, stay strong, and for God's sakes, get involved. See you next week.